Hi everyone. I am pleased to have worked with the Municipal Planning Assistance Program to put together a session on site plan review, which had come up as a topic that folks were interested in. So I am pleased to introduce Attorney Leah Rachin. I think I got that right, but let me know, Leah.
Close enough. Rachin.
Rachin.
Close enough.
Leah focuses her practice on municipal land use and employment law with over 20 years of practice experience. She serves as town attorney to several municipalities. I actually got introduced to her through Yarmouth Town Council, our legal counsel. So I'm pleased that she was agreeing to join us. But she advises towns and other public sector clients on a broad range of issues, such as planning, zoning, licensing and permitting, charter and ordinance drafting and interpretation, voting and elections, property taxes, contracts, and employment matters, all the things that are important for municipalities. It also serves on boards in the communities that she works in or that she lives in, and just all around great municipal attorneys. So I think I will leave it there and turn it over to Leah to get underway. And if you either Abe or Avery, let her have permission to share her screen if needed.
Yeah, thank you. I will need that. Well, thanks, Erin, for that kind introduction. I appreciate it. I will say that the stuff that you said is interesting, but I'm really enjoying watching the chat with the music piece coming up. And I have to say that I have absolutely no musical talent, but if I can have vicarious credit for the fact that I gave birth to a musician and that's his career, I'm going to take full credit for that. So anyway, just launching into this presentation, I wanted to say, just as a introductory comment, I will say that when I was speaking with Erin, she indicated that there were a lot of folks who are fairly new planners, either just in their careers or new to Maine, and so that the approach here is somewhat of a 100 level approach to site plan review. Now that said, I am looking at the folks who are out there, and I recognize some names that are obviously veterans here. And so what I would ask of you, and all of you, frankly, is to help me not have to listen to my own voice for this entire time we share together. I will say that I did a presentation last night on a totally different issue, freedom of access, which we may touch on a little bit. Last night, there were about 50 people, and it was so much fun because they actually listened to me when I said, please interact. If you have a question, let's not leave it to a Q&A at the end. Ask now, and we can have a Q&A at the end, but just ask now, raise your hands. And for those who are veterans, please give us your tricks of the trade or traps for the unwary or nightmare stories, because those are ways that I think we all learn, and we learn from each other. So please help a girl out here and jump in if you do have questions, okay? So, let's start at the beginning, right? What is site plan review? It's a locally developed system for reviewing new sort of non-residential uses and commercial retail service. Now, in some communities, you do have site plans for multi-family residential uses. But I guess what I'm trying to say here is that with site plan, it is very much a local creature, and you represent obviously lots of municipalities here. And I would imagine that the site plan review process, standards, etc., are very different, considering, depending upon who I'd be talking to. But at basically, the point is to assure that, public health, safety, welfare, environmental issues, and sometimes these, what we affectionately refer to as good neighbor standards, those are the things that are addressed. And basically, again, because we know subdivision review is mandatory by statute, and that applies to residential uses, larger residential uses, there really is nothing mandated by statute, right? So that's where home rule code comes in, and each community can enact site plan regulations that are appropriate for their particular municipality. And so other things, so let's talk about, drill down a little bit. What kinds of issues, when I say public health, safety and welfare, environmental, we're talking about, again, it's going to sound hauntingly familiar. It's very similar to subdivision, right? Access, circulation, traffic, stormwater, groundwater protection, hazardous waste, you know what we're talking about here. And these are the factors that are always, not always, but mostly enacted in the ordinance to address these public health, safety, and environmental factors. Some communities also, as I said, get into these good neighbor standards when we're talking about buffering and screening and noise levels and odors. Light, I don't know if you're finding this in your communities, but light tends to be a big issue now. A lot of abutters particularly are concerned about those things. And then some communities go even further, and they're talking about how the project will fit within the particular environment and the character of the surrounding neighborhood. And so those kinds of considerations would be landscape design. Oh my goodness, I didn't have my PowerPoint. I'm so sorry, folks. Bear with me. Can you see that? Oh, good. I apologize. Let me just catch up with myself if you don't mind. All right, here we are. Okay. And so one of the things that I don't know if you are finding, but these sort of architectural and design standards are something that I think in different communities, they're either absolutely embraced, depending upon how much control towns want to exercise on sort of aesthetics, particularly in those village or downtown areas. And, you know, I'd really love to know, frankly, how widespread the use of them are. I know that larger municipalities sometimes do want to have more control about the look and feel of projects within, especially those downtown areas, but some are basically like, nope, depending on the local flavor of your community, it's like, heck no, don't tell us what we want things to look like. And, you know, it would just be interesting to hear about how many of your communities actually have them or not. I don't know if anybody. Okay, well, I'll move on then. But what I will say is what's really critically important, particularly in the case law that's been developing around these issues, is that you need to have tangible standards, right? Tangible standards that, you know, that we can talk about whether or not these criteria have been met. And, you know, there's some information in later portion of the submissions, but you've probably heard these terms, void for vagueness, or void for vagueness is a term most people are familiar with, but there's also these this concept of unlawful delegation of legislative authority. That's a mouthful, but it's essentially the same thing. And basically what it means is, hey, if you are an applicant, if you're a member of the public, if you are a court who's reviewing a decision, you want to know what the actual criteria is. Not there has to be some standards that people can actually appreciate of what is it that I as an applicant what are the standards that I'm going to be held to. And there have been lots of cases in Maine where the courts have said, you know what, that standard, it's vague. We don't know what it means. And this notion of unlawful delegation of legislative authority basically means that it allows the board or whatever the reviewing authority is just to kind of make things up as they go along. And there's this notion of arbitrariness and capriciousness. And so I'm going to just go through a few of the cases out there that have addressed this. And one of the standards, and again, I'm going to throw it out to you. If you feel like saying, hey, I think that would pass muster or not, feel free. But there's one standard out of this case called Kasulka. This was a 2000 case. And the criteria was anything that is proposed, one of the review criteria is that it must conserve natural beauty. Now, do you think that is a standard that's sufficiently specific specific, that gives applicants and courts and members of the public to know what that actually means? No, you're right. So what happened there is the court said, nope, that's not okay. It's void. And what it allows, and when we say unlawful delegation of legislative authority, what that really means is it allows board members to basically say, well, this is one of those, beauty is in the eye of the beholder, right? And it's not a tangible standard, and it doesn't give a sufficient notice to the public or applicants as to what that standard is. So that standard was struck. But here's one in a subsequent case, and it sounds somewhat familiar with respect to the conserved natural beauty. It seems a little bit familiar and similar to Casalca. This was in a Giuliano case, and it basically, here's the criteria. The use won't interfere with existing scenic and aesthetic uses. Anyone have a sense of whether or not that one was upheld? Well, the court in that case actually said, that's okay. And it seemed, when I first read that, I was kind of scratching my head thinking, well, that seems, existing scenic and aesthetic uses, how is that materially different from conserved natural beauty? Well, it's different because of the word existing. The court said, okay, you know what? Existing scenic and aesthetic uses nearby, I can look to my left, I can look to my right, I can look all around, see what those existing uses were, and then that's my barometer or yardstick for determining whether or not the standard is met. So that one was upheld. One more, the use will comply with health, safety, and welfare of public and the essential character of the area. I think you can probably guess by now that standard was not upheld, found that it was just void for vagueness and that it wasn't sufficiently clear. So these are the kinds of things when you're looking at your ordinance, your site plan ordinance or provision, you got to figure out, is this one going to be subject for challenge? Have you had issues in the past? And as again, in your role as planners, that's something that you can really bring value to the municipality, because you, and I think code enforcement officers, frankly, are the front line. When you're starting to see issues with your ordinances, you can, and arguably should, bring that to the attention of the town, saying, you know what, we're having issues with this. This is something I'm concerned about. And maybe we might want to think about an amendment next time we have a town meeting. So these are just kind of things to keep on your radar. So again, what does site plan review address? And we all know climate change is here, or I wouldn't say everybody agrees with that. I think there's increasing agreement that that is the case, particularly planners. And so, climate issues are a big deal. And I have seen certainly revisions to ordinances to try to assist with resiliency, particularly with those kinds of criteria dealing with erosion control and stormwater and impervious surface standards. So that is definitely something we're seeing more of. Again, we talked about how site plan really is very much analogous to subdivision review. It is not required, but certainly, I think, recommended, particularly, and, as I said, what a community does in its particular backyard very much depends. I think what would happen in Portland or Sanford would be a little bit different than what might be happening in Waterboro or Sebago, right? So it is, this is Maine, we live in Maine, home rule is a wonderful and powerful thing. And this is a particular area where municipalities can absolutely use home rule to cater to their particular community. One thing to be, I keep talking about subdivision and site plan and how they are somewhat and are different, but you should be aware, and you probably are, is that in 2018, the subdivision statute was amended. And basically, if you have a new or existing structure that's divided into 3 or more dwelling units, it can be exempt from subdivision review if the municipal site plan review takes that on, right? And so if your community does actually regulate multifamily developments, which some do under site plan, then that is exempt from subdivision review. However, it's important to recognize that if you do in fact choose to regulate these multifamily developments through site plan, that those review criteria, those section 404 review criteria have to be met with respect to that particular review. So don't forget that. So we talked about what what site plan review does address. Equally as important is what it does not address, right? So if we're dealing with the creation of lots, those are not a site plan issue. Those are subdivision. Those happen through your subdivision regs. If we're talking about standards for construction, right? We talked about design and whatnot, but I'm talking about construction issues. These are dealt with land use ordinances, building permits, and of course, MUBEC. We all know about MUBEC, right? We have to make sure that any construction complies with the requirements of the main uniform building. And that is not a site plan issue, right? Also, what site plan does not address, provisions dealing with, where development should occur. And that, of course, is a zoning question, right? That has to be addressed through zoning. Same for space and bulk issues, lot size, street frontage. These are not site plan issues. These are land use and zoning issues. Now,
Leah?
Yes.
Just wanted, I'm not sure if you can see our hands. I wanted to jump in with a question, if that's okay.
Yes, please. I don't see hands, unfortunately. I see you, but I don't see a hand up.
Oh, I took it down, but I wasn't sure if you're seeing it at all.
No, thank you. Erin, could I ask you, please, because I'm in my screen sharing mode, I only can see a few folks. If there's a hand, will you just jump in and let me know?
Absolutely.
I appreciate it. Okay, Judith, please.
So going back to, and this is kind of related to the last bullet here, and what are objective and standards that can be upheld. There is a current proposal. It's sitting on appropriations. Bunch of things are. We don't know if it'll come off.
No kidding.
Yeah. But it's to prepare for my bureau to issue an RFP for pre-approved building types.
Oh, I saw that. Yes.
So could be housing especially, but also commercial. And I'm wondering what your thoughts are in terms of how that could help with the objective standards that you think are important, the less vagueness, as it were. And then I see you've got height here.
Where here?
As
far as, yes.
I mean, I can see that would be in a zoning ordinance, but wouldn't it also be in a site plan review ordinance?
I think it could. I guess what I'm saying is that, and I'll answer in opposite order, but you'll remind me if I forget.
Okay.
When it comes to, I guess what I was focusing on really is the space and bulk notions, these dimensional requirements.
Yeah.
Because I think of those, lot size, street frontage, and maybe not height, but I do think of height. Most towns have these 35 feet standards or 40. And the reason why I lump those together is because when we get into the later consideration of waivers, I am concerned about any kind of waiver of a space or bulk requirement, because that becomes akin to a variance, which is only something that the ZBA or the Board of Appeals can authorize. And so when I see any kind of dimensional type requirement in a site plan ordinance, I get angsty about it because I'm worried that there will be waiver from those. But with respect, I did see that we're actually doing another seminar for the Building Inspectors Association later in May, and we always do like a legal update and look through what's on the table, what's out there. And I did see that, and I think I'm glad you emphasized that was also for commercial buildings, because I didn't pick up on that. I thought it was really only for, and that was my mistake. I made an assumption. I thought it was, there's so much in light of LD 2003 and the clear signal from the legislature that affordable housing and making every possible effort in that regard. I thought of that as, hey, this is going to make affordable housing more affordable because we have these, units that will be designated. But what I don't know, Judith, and maybe you can speak to this, is that are those, I don't want to call them prefab, but like a pre-approved design, I would imagine those have been cross-checked with the requirements of MUBEC to make sure that they actually comply with those. Are you aware?
They would certainly have to be. We would include that requirement in the RFP. And now that you're questioning whether it includes commercial, I'm checking. But
No. And please, no. I am not. I'm in no way challenging you. I just thought, oh, this is cool because this is forwarding the goals of, you know, affordable housing. But
yeah, well, I think you may be right though. So I'm checking.
Yeah.
So yeah. Thanks.
So I think that I look at that as very much within the mandate, and probably the impetus for that is just to keep on hammering away at affordable housing. So I'm not sure if I answered your question there.
No, you did. Thank you.
Okay, my pleasure. Okay.
And before you move on, Leah, there is another hand.
Oh, great.
And then a question in the chat about not reviewing, I guess, the bulk and space issues as part of site plan. So I think either order.
Whoever is, I can't see the hand up, so please just pipe in with your questions. That would
Sure.
be wonderful.
Can you hear me? This is Heron Weston, and I work in Washington County.
Great.
And we have a lot of towns without zoning. And I'm just looking at this list of what site plan doesn't do. And I'm thinking, if you had site plan, first of all, is it possible to have site plan review without zoning? And if you did, then it would end up doing a lot of these things you say it doesn't do. I can imagine, i.e. we might want not have this kind of development here, but instead have it over there.
Yeah. So
or just how those things interact.
No, I think it's a fantastic question because, like we said, we're dealing with big municipalities, small municipalities, and they all do things differently. And a lot of towns have their site plan criteria incorporated with, and their shoreland zoning, and their, you know, all of the kinds of ordinances are all part and parcel of their land use / zoning ordinance, right? Some of them, and we can talk about this, have freestanding site plan ordinances, and that is very much more the case and probably more appropriate for those towns, like you say, that don't have zoning. But one thing I wanted to make sure everyone understands, and I'm embarrassed to say, but I feel like I need to confess, it took me like a while to understand, oh, land use ordinance, zoning ordinance, it's the same thing, right? Well, we know for sure that it is not the same thing, right? They deal with a lot of the same issues, but we represent several towns that don't have zoning, like you say. But there's a land use ordinance, and it has very strong criteria, like we were saying, space and bulk and all of those things. They just apply universally town-wide. Whereas the difference between a land use ordinance per se and a zoning ordinance simply impose different criteria depending upon where you are in different parts of town. So when it comes to what can be addressed in site plan review, like I said, we went back to those earlier bullets where, you know, a lot of things can be addressed. But I think what I'm saying is that when it comes to bulk and space, you know, requirements, those are dimensional. Those are things that, again, that can be a land use ordinance and applied equally throughout town, so long as those space and bulk requirements are the same everywhere. The minute we start getting into different, okay, you have a 1 acre lot size out in the rural zone and a ½ acre, or, you know, and different frontage requirements downtown, there's a different frontage or different setback requirements. If they're different in different parts of town, that's zoning, right? That's the difference. But is Heron, is that how you pronounce your name?
Yes.
I'm sorry. When it comes to how they dovetail, I think that, you know, a lot can be accomplished through site plan. But again, those are usually for non-residential uses, right? And those are things that, and again, you may use them for multifamily, but if you do, then you're really into subdivision, those stringent criteria that you got to make sure that are dealt with. But tell me, do you have any more specific questions that I haven't answered?
Well, I was just imagining that through site plan review without zoning, they could say that's not appropriate here, and we don't allow this type of development here.
Yeah, I feel like that's a zoning ordinance. I think it's really critical to keep those concepts, and they're hard to keep conceptually distinct. I think they really blend in. But if you're going to impose different requirements for different parts of town, I think that gets really into the zoning piece. Okay.
Thank you.
Yeah, my pleasure. Okay. Get moving along.
One other quick question that's
Oh, yes,
probably
please.
still on this topic. In the chat, Michael Martone asks, are there any issues that are explicitly not allowed to be regulated under site plan review?
I think the only things that really come to mind are zoning, right? Yeah, I think that's the one that immediately pops in. But again, I think those space and bulk things are very much a land use ordinance thing. And there's nothing to say that site plan standards aren't incorporated into your land use ordinance. In fact, in many places they are. But I think that when I think about site plan, I think about, as I say, sort of non-residential uses and how we want them to look, what those standards are to make sure, and again, this is really broad brush, but it is very much about public health, safety, welfare, environment. And if we want to get into those good neighbor standards, like we want a buffer, we want to make sure that, you know, and oh gosh, this is a whole kettle of fish that we probably don't want to get into, but those noise standards, that's something that creates a lot of a buttered concern. But when it comes to where something is in town, I don't think that's a site plan thing. When it comes to how big your lots should be, how much frontage you should have, I don't think that's a site plan. Those are land use and zoning ordinance issues. And if people disagree, or if people say, wait a second, we have those in our site plan standards, I would love to hear about it, because, you know, I'm just a lawyer sitting in my office. You're the ones on the ground doing the actual work. Erin, have we got any comments there? Should I keep going?
I think you're good to keep going. Thanks.
Okay, thank you. And so, like I said, these standards, depending upon your town, sometimes they're freestanding, sometimes they're incorporated. Like I said, I think it really depends on kind of the size of your town and your community, and how things are done from an administrative standpoint. Here's something, and this is, again, we're back to that home rule, every town is different kind of thing in Maine, where, you know, many communities really see, hey, this is a great idea, we want to have this for larger projects, but, you know, we don't really want to impose a lot of this burden on, you know, I mean, there's Walmart and then there's a mom and pop shop, right? And I think a lot of towns are saying, you know, I think we really don't, one size does not fit all, and we want to have different criteria and standards. And so, as you would see in some communities where, you know, for a subdivision, you have minor and major subdivision approval, and the standards and the submission criteria for those two different kinds of things are different, right? Same can apply for the site plan review process. And so, like I said, you know, how a community structures its process, not only how, but who actually is the reviewing body there, that looks very, very different in different communities. And a lot of it is based on staff, how much staff you have, workload, and just, you know, preference, right? So in many communities, if not most, I think the planning board actually select, you know, they are the ones that take on the review. That's because planning boards already exist. They have to exist, right? Some towns actually have a separate site plan review committee, and it's similar to the planning board, but they just do site plan reviews. Some actually, and this of course is usually in larger communities where they have the staff to do this, have site review committees where, you know, you got the fire chief and the police chief and the code enforcement officer. If you have a town manager, the planner, they all, you know, every couple of weeks you meet in a conference room and go through these things. Now, again, I think it's really important to think about for your community, what's best here? How does it work? Is it working? And just because something is done and has been done in a certain way for time immemorial, doesn't mean you can't switch it up a little bit, right? Some towns, and I will say, I don't represent any of them, and I'm not sure if this is still a thing. They have the staff sign-off process where, you know, it's basically a progression party where the application goes to these various staff and, you know, yep, public works looks good, fire department, fine, PD, yep, we like it. And it gets those rotating approvals essentially. And what I will say, while that may be a possibility, I don't like that as a town attorney, and the reason why I don't is simply because of freedom of access issues, public meeting requirements. You know, in some ways it's easy because you don't have to listen to all of the angry abutters who don't like a particular project, but that is a huge part of the process, right? And that's why we have freedom of access laws and open meetings and public proceedings where there's supposed to be transparency. And so I could see if that is the process used, unless there was some possible, you know, final public hearing before any of these things were ultimately approved. That could be a serious problem, I think. Has anyone encountered that? Does anybody use that process? No. Well, that's good. I'm glad to hear it.
I'll just jump in and say, like, as a random caveat, coming from doing planning in New York, that was actually one of the big requirements there, was like everybody had to look through the application. And in having that experience comparatively to now, I agree with what you said, because I think it is a little bit easier to, you know, keep track rather than chasing everybody down and then making sure you have all that information readily available. So thanks.
No, I appreciate that. And I should make sure that I'm clear that just because you might not have that rotating process, a lot of the time, you know, subdivision review, site plan, any kind of planning board process, you know, usually there is the requirement that you have that sign off from the fire chief saying, yep, the access here, the trucks can turn around. And so the same kind of, what I'm looking for, checks and balances are there. They just happen in a different way. And it does give the public the opportunity, if it's a site plan committee or a planning board review, that allows for more public input. And I will say, let me ask you this, and I'm lobbing it back into your court a little bit, that I know plenty of towns I know have staff review, right? And that's perfectly acceptable. I wonder, just to help me get over my indigestion around the sort of the public access FOA requirements, is there public participation allowed, welcome? I would imagine that those staff review committee meetings are or should be open to the public, so folks do want to come. But I would imagine also that the abutter notice process is done so that folks, if they do want to participate, either showing up at the meeting or submitting some written comments or objections, that's contemplated.
Hi, Leah.
Hi.
So we have a two-step process. We have I'm in Presque Isle, and I happen to be the code officer and reviewer of all things at the moment.
She's cook and bottle washer, basically.
Yeah, I do it all. So
Yeah.
With that, we set some clear triggers for what goes to planning board review and approval versus what might be administratively approved here in-house. But either way, we do a team. There's the fire chief and tax assessing, and we've got a city engineer involved. We get public works involved, utilities involved. We invite them. Sometimes they show up, sometimes they don't.
Sure.
To the meeting, and if everybody's good with it, we send it up to the planning board for review. Although we don't get any public participation out of it. Very rarely does anybody actually show up for this.
Oh, for sure. And I will say that that's not the issue about public participation. It's just giving folks the opportunity if they are so inclined. And if that's done, then I'm a happy person, because then you know, a year from now when somebody comes back from Florida and says, what the heck, I didn't know about this. And then they appeal and you go to court and then they have to argue about the good cause exception, which is that all that body of case law, which basically is everyone who lives in Florida comes back to their summer camp and sees, wait a second, that used to be a vacant lot. What happened? You know, it's great. So as long as there's notice and abutters have been notified, we're done. We don't need to say, hey, come on out. What do you really think about this, right?
With that, I guess one of my questions is, where should we notify abutters? So in our land use code, which we have land use and zoning, and part of that is our standards for review. That's where our site plan review falls in.
Sure.
Like, we have permitted uses. We have a whole chart of what's permitted, what's special exception, what goes where, in all the different zones. With that, like, we might review for a site plan, a commercial development that is permitted. So there's no like special exception. It's still permitted, but we go through the site plan process to make sure that the stormwater's in place, the parking egress access, the fire department's happy with it, all of those other pieces. So I've been doing this for a couple of years, so not very long. We don't notify the neighbors in this case, because it's a permitted use. It's been a permitted use. Should we be notifying?
Oh gosh, that is a loaded question, right?
Okay.
So I mean, I'm gonna like dumb it down to its essence, right? That let's just forget about commercial stuff. Let's talk about a single family home, right? Some towns a butter notifies, some don't. I mean, for porch, hey, can I put a porch on my house? Some towns do a butter notification, some don't. If you're asking me, should you, I'm going to leave any of those like normative, moral things aside. From a legal aspect, the reason I say notice, oh gosh, I could spend an hour talking about this. The notice piece, lawyers like the notice piece because it heads off at the past those appeals after the fact, right? And if you have notice, and if you can say, look we send these out, here's the green cards to show it, that's really helpful to head off at a pass, an appeal. That said, considering you're the code officer, chief, cook and bottle washer, something tells me that you're really not feeling the love about having to notify every abutter every time somebody wants to like put a screen porch in, right? I mean, I'm going to go out on a limb and say that that's not something you're really chomping at the bit to do. So I totally appreciate that. I also know that some towns have taken the approach saying, look, we don't have enough staff time to do that. You're the applicant, you notify the abutters and you show us that you've done that. I think that to me, in towns where you don't have huge amounts of staff to deal with this, I think that's a great way to handle it, frankly. And then, the bottom line is, as the town, the permitting or approving body, you're still holding the bag if somebody wants to appeal that permit. But then kind of the laboring or when it comes to defending that appeal kind of transfers over to the abutter in that regard.
Okay.
So if the question is, should you, I think from a legal perspective, it's not legally required. The balancing factors are, yay, it's great to head off at the past sort of possible appeals with a butter saying, hey, I never knew about this, I should have been told. However, like I said, you only have so much time in a day and sometimes you don't have the staff to do that. So it's really kind of a practical on the ground determination as to whether or not you do that. But as I said, one of the wiggle ways to get around it is to make the applicant do the notification.
Okay, thank you.
My pleasure. Erin, any other questions?
There's two in the chat relative to limits or support of police, fire, and life safety review. And then the second one is regarding using registered mail to prove that you send out butter letters.
That's great. All right.
Yeah.
So that first one, I think I'm going to need a little bit more. So the person who asked it, maybe they can chime in. But as far as, I'll take the easier one first, is about the registered cards. When it comes to notice, I like more. Sometimes more is more, sometimes less is more. When it comes to notice, more is more. And so when I talk about these notifications, whether it be for a butter notification or particularly like code enforcement officers doing notices of violation, love the green card, love it, okay? And I also say spend money on the stamp too, because we know that a lot of people see those green cards, especially if they're mostly on the naughty list, they know that green card doesn't mean something good, right? So if you go to court and say, yes, we sent the notification, and the judge says, well, the green card came back, clearly they didn't get it, we say, well, Your Honor, we sent them a regular one too. So that I have found is just a trick of the trade that is a lot more practical, and it works better, right? So, and also if somebody doesn't live there anymore, you know, then notice is a quagmire that we can get into if we have time. But like I said, yes, green cards, we like those. Do, you know, spend the money on the stamp too. That often is a good way of dealing with it. And help me understand that first question. I'm a little
Yeah, so the participant is Michael, and he added, how do we defend or change, or how do we defend a change or requirement required by the fire or police chief?
Oh, I see. Yeah, that's a great question. I think that it sort of depends on what the issue is, but the rule of thumb always when it comes to any kind of review is let's be able to tie whatever request or change to some kind of governing standard, right? And that is, I mean, that's kind of back to one of the things I was talking about, this unlawful delegation of legislative authority. We always want to be able to say, yeah, I'm going to tell you that I need you to have a bigger turning radius. Well, that's because trucks are X feet wide and we need to have that, right? Or section blah of the life safety code requires, you know, I don't know, I'll make something up, but you know what I mean? Like the standard, there has to be some objective criteria or standard. You can't just say, ooh, you know, fire chief or police chief is, you know, I want a turning area of 300 feet because in 3 years from now, we might get this super truck that doesn't even exist now, you know, those kinds of things. So just be reasonable. I think that's really the criteria. Let it be reasonably related to some actual criteria. Does it have to be in the ordinance? No. If it's a police thing or you know, about well, let me be clear. Either it has to be in the ordinance or related to a standard. And if that standard is fire safety, it could be in the life safety code. See what I mean? So hopefully, does that answer the question? You're muted, Erin.
Yeah, I think it gets to the point that he followed up with, basically, can they make up any requirement that they want? So that has to be rooted in some specific code or standard.
Yep, I think so. Yeah. And I wanted to say, I would go so far is that I don't, some attorneys might shockingly disagree with me. I can't imagine why anyone would ever disagree with me about anything, but they do. So some might say if it's not in the ordinance itself, then you can't press it. But I'm going to go out on a limb and say if fire safety is one of those criteria, the life safety code kind of dictates what fire safety is, and therefore I think you could reasonably, I'd take that case any day. Let's put it that way. Okay. All right. Anything else out there before I launch into the fascinating world of pre-application process?
I think we're good. And just for a time check, we're about halfway through the
time. Oh my God, we haven't even gotten past. All right, let me go through. I mean, the bottom line about pre-application is it's really helpful for applicant and town to know what, even conceptually, what's going on here, right? We want to communicate with the applicant early and often and give them an opportunity to come on in. If you have a planning board and a planner, then great, meet with the planner. If you have a town of 5,000 people and you only have a planning board and you don't have a planner, then have a pre-application meeting just so everybody knows what the process is, what the governing standards are, what is contemplated, give the applicant an opportunity to hear, you know, you're going to have some members of that planning board who are, and you know what I'm talking about, you have everyone's got an issue, right? Some people have, you know, it's stormwater. Some people it's, you know, oh my gosh, it's the salamanders or the bunnies or and I'm not minimizing, but you know what I'm talking about, right? So that an applicant and the board or the reviewing authority should have an opportunity to have that informal dialogue so that before that application is put in, the applicant knows what is important. And of course, all the criteria are important, but, you know, they might have to spend a little extra time on X, Y, or Z. So that, you know, I'm not going to go through, you know, this pre-application process, but that's the bottom line as to what the importance of that is. Okay. And so similarly, sketch plans, some towns require that. In addition to a pre-application, I think it's fair to say you could do either or, unless it's a, you know, a big city type situation or the project is really, really big. But just the takeaway there is that don't just have your first meeting launching into, you know, here's the plans, here's the engineering, you've got your 14 sheets. It's just nice to have that initial opportunity for everybody to put their heads together. All right, so application phase. We've got your submission requirements, and it cannot begin until that information is there. And while some communities provide a level of flexibility, like what's required, depending on the scope and the size, I think it's really important. Again, I'm going to be very legalistic here, but if you have criteria, make sure you apply that criteria consistently, because you know that there are going to be situations where, I mean, it's like the sibling thing. Well, you didn't make him do it, and why did he got to do it and I didn't? And then what happens is, if any of the folks who are the applicants are part of, say, an enumerated class within the Human Rights Act, you know, then they can say, you know what, you're discriminating against me because X, Y, or Z, right? So just, and also it's just the right thing to do. Treat applicants similarly, fairly, consistently across the board. Now, this is not in the materials, but I wanted to talk to you a little bit about your staff, right? Your staff to the board, and you can only control so much. And I'm sure there are times when you're sitting there and you're hearing your board members say things that you're like, did they just say that, right? I see people shaking their heads, smiling. Yeah. So in those circumstances, and it's delicate, right? Your staff, they're the board. I guess what I would say, and I've seen it done very gently, very compassionately, but if you see things just going off the rails, that I think you can and should bring things back and always just be encouraging that, you know, let's look at the criteria and let's make sure what's being discussed is reasonably related to the criteria. And I mean, a particular board member might not like that, but it certainly is in the town's best interest for you to do those kinds of things, okay? And if you have any questions around that, I'm happy to entertain those. I know they might be a little sensitive, but understand that I know you want to stay in your lane, but also appreciate that you're doing the town a favor sometimes if things are coming off the rails and people are talking about things that really should not be part of the consideration of the board when they're reviewing the project, okay? All right, so we know what the typical submissions requirements, I don't need to go through those, but one thing I do want to talk about is right title and interest. And I don't know if that's something that in your communities is becoming more of a battleground, but I will tell you that there has been a case in the past few years, this Tomasino case, that honestly has thrown everything that I have always advised clients and boards on it's just flipped it. So it has always been the case where, you know, somebody submits a deed, they submit an easement, they submit a purchase and sale agreement. That's it. They have right title and interest. The board does not and should not go behind that, right? I mean, people on boards are very wonderful, well-intended, like volunteers. Very few of them are real estate attorneys that are adept at analyzing the contents of a deed or an easement, right? So we've always advised that, hey, if there's a deed that you look at it and you're like, oh yeah, that makes sense, you don't go behind that. Now, this Tomasino case, and again, different attorneys will probably disagree on the importance or the impact of this case, but because there haven't been subsequent cases where the law court says, oh, this is what we really meant about that case, we're not quite sure. But I don't know if you've ever had the situation where you have the applicant and then the abutter says, no, they don't have the right to do that. That's my property, or the scope of the easement doesn't let them do what they want to do. If that is the case, I guess my takeaway here is it used to be, we would say, oh, that's a civil matter, we don't get involved with that. That's, you run with that. If that comes up, call your friendly town attorney, and I'm not trying to do the Lawyers Full Employment Act here, but it is really an important matter that it's something that you could be stepping in it if there is a dispute essentially on right, title, and interest. That's when you want to call your town attorney, okay? All right, so once the form, the submission criteria have been submitted, that's when you get into the substantive review. Now, that is really, oh, we're gonna forget about this. We already talked about the butter notification, but let me talk a little bit about substantive review. It's really important because I'm sure you've heard about, your towns, different towns have different things, but there's a lot of ordinance amendments going on. Often, an application will come before you, and it's, I don't know, what's a hot button issue? Oh, solar, okay, a solar farm. Some people love solar farms, especially if they're not in their backyard. If they are in their backyard, they don't like these, right? And so there has been moratorium or whatever they use, large scale extraction, the scenario. Citizens group comes in, imposes or enacts a moratoria retroactively, right? And this happens a lot. So it used to be the case, and up until literally 2 weeks ago, where the issue is substantive review. Just because you get your application in doesn't mean you're safe from retroactivity. What it used to be is that you have to have, submitting isn't enough. The board actually has to start a substantive review of the review criteria in order for you to be safe. Just recently, like in the past month or so, I can't remember the LD number, but I think it's 772 or 727, has been passed by the legislature. And again, this is in the context of, I think, affordable housing. If there has been an application, a subdivision, or something that involves housing, then there can be no retroactive moratorium. The date is no longer the substantive review, it is the date of submission of the application. And that's a big deal because, bottom line is those scrambles to get a retroactive moratorium passed are not going to be effective anymore if somebody's already gotten their application in. It used to be, it wasn't good enough to get the application. You actually have to start the review process. So, where are we? Okay, site walks. And I'm kind of jumping all over the place here, but site walks, and this is, I'm going to flag this, and this is for you as planners, as advising your boards, and when they sometimes go off in directions they shouldn't, right? Site walks, right? That's important. They happen, they're noticed, members of the public get to go to them. What if you have a planning board member who, it's in another part of town, and they're like, yeah, I'm just gonna go check that out. Is that okay? I tell board members, please don't do that. But if you do, and you have some concerns that are going to inform your decision about whether or not to approve a project, you want to raise those concerns. You want to say what's in your mind. I saw this, it's wet. What about the buffer? You need to have those planning board members speak about those in public, talk about what their concerns are, and allow the parties to address those concerns. Otherwise, that is, the decision is possibly subject to due process concerns because the applicant didn't have an opportunity to address something that was relevant to the decision-making process. And that same can be true of anything. I would say oftentimes planning board members who, out of sheer diligence and because they want to do their job well, they'll start Googling stuff, or they'll start, thinking about, habitat and whatnot that none of the parties have raised, right? If they do that, I do try to tell planning board members, slow your roll. You're the judge. Let the parties tell you what is relevant and resist the urge to go off and do your own research. If you do your own research and it's something that you're concerned about that's going to inform your decision, you need to disclose it. You need to ask the parties to address it. So that's something that I think it's important for folks to know. All right, technical review. Again, in those communities where you don't have staff, we want to make sure that they are being reviewed by the appropriate people, right? And you have a list of resources here. If, again, back to habitat, the cottontails, get inland fish and wildlife involved if the parties don't. These are your resources. I will say, I have two cases right now where water is a major issue, and one of the parties who is actually objecting to a project is the local water district, right? So in that case, you have a water district who the superintendent is extremely knowledgeable about water and recharge areas and all of that kind of stuff. That's a classic situation when you want to have an independent third party come in. And the trick of the trade there is to make sure in your ordinances, there's actually a provision that allows you to pass along those kinds of costs from an independent third party review onto the applicant. Important. So how are we doing for time?
Looking good.
All right. Oh goodness, fun with findings. Okay, so as planning staff, this is. I mean, you have many important jobs, but I have a haunting suspicion that the planning board, they're not writing their own findings. Fair to say, and sometimes that's a good thing, right? The findings of fact and conclusions of law, those are critical, and doing a good job on them is becoming increasingly more critical. Why do we want these? Is it, again, just to make planning boards and planners' lives more onerous? No, it's because law requires it. Under the Freedom of Access Act, if there is a written decision on an application, there has to be a written record of that. And also under case law, which I would say in the past 3 years, the law court, Maine's highest court, has said basically to towns, how many times do I have to tell you findings are important, and if you don't do them, we're gonna make you see it again. So it's gonna be deja vu all over again, and we're gonna remand it back to you. And they have repeatedly, much to the chagrin of not just planning boards, but code officers now. Like it's kind of getting I'm editorializing a little bit, but to require code enforcement officers to be writing written findings of fact every time they deny or issue a building permit is a little bit much. But anyway, I guess the point is here is that I don't want to have this session go by without really emphasizing the importance of findings. All right. What are they? Findings of fact. Properties located, lot on map, such and such, blah, 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 blah. Now, those are the easy ones. But what happens when you have that big project where you've got the abutters and they're fighting over certain issues? What is not good is to say the applicant says blah, and then the abutters say blah, and just leave it at that. Those aren't findings, right? Those are recitations of fact, but those are not findings of fact. So the planning board, whoever the staff review committee, whomever is the reviewing authority, has to kind of be the tiebreaker. And you would say, we find, so-and-so says this, so-and-so says that, but we find this because, and the because is really, really important. If there's competing evidence, if there are the battle of the experts, which is often the case, you need to say, we favor the evidence of so-and-so because, right? and that's critical. And the conclusions of law are basically the dovetailing piece. We find that this criteria is met because, and here's what the evidence is. All right. So those are really important. I have to tell you, I have seen it so many times where you have the template of the review criteria and it will say, you know, traffic met, stormwater met, you know, and that's not good enough. All right. The stormwater provisions are met because of the such and such plan presented by so-and-so engineer, and that meets our criteria. Just to show that you can't just say it's met, and you can't just say it's met based on the plan. You want to say, you know, why, a little bit more. So again, I don't expect, or nor am I advising that there should be a tome for every criteria, but let me say, particularly if there is a project that is, you know, subject to a lot of public scrutiny or objection, you want to spend more time on those particular areas. And they're often traffic, often access, often water. You know what those ones are. And so when you're hearing chatter from butters that we don't like this, you want to be really sure that particularly with those criteria, you want to make sure that those are well written and well substantiated. Okay. And that's kind of a good segue into the appeal piece, right? Because these findings are what is going to determine, and I shouldn't say win or lose. I mean, the evidence will speak for itself, but you've got to give the court or the Board of Appeals some fodder for making a decision to figure out whether they got it right or they got it wrong. Okay. Now, I don't know how you deal with this. Different communities deal with things differently. Sometimes there is an appeal to the Board of Appeals first, and from a planning board decision, I mean, that's pretty agonizing, right? That depending on the level of review, some boards of appeals have what we call appellate review, which is they are just reviewing whether you got it right or wrong, you being the board or the code officer, whomever, if you got it right based on the evidence and the record that was in front of that person. Or there's a de novo review, which basically means exactly what it sounds. It's from scratch. And in a situation where we're dealing with an appeal from a subdivision or a site plan, that can take meeting after meeting because essentially you're doing it from scratch. So I don't know what your folks do, but I have to say when it comes to subdivision or site plan, I definitely prefer a direct appeal to court rather than your municipal boards. Let's see what else. Let's just make sure. Yeah, as far as post-approval, just because they get their approval, it shouldn't end there. I don't know if your ordinances speak to it, but they should, especially with respect to the right to inspect during the construction process, just to make sure everything's going well. Performance guarantees. These are great. They are fantastic. And what happens often, especially if it's, I mean, we love, you know, actual letters of credit or escrow. When it comes to like these bonds, I don't know if you find this, but, and it's getting less and less, bonds are used less and less, but oftentimes we would have a bond that would last for 3 years, and wouldn't you know it, like 3.5 years later, you realize the road wasn't constructed to spec and the bond's lost because the period of time has lapsed. So I would just say, again, trick of the trade, you want to, if bonds are being used as a guarantee, you want to diarize big time what that deadline is. Like do inspections 6 months before so you make sure you don't lose your ability to collect on that bond. Okay. Let's see. Oh, as built for if there are changes after you know, or during the construction process. I'm sure you know, and most ordinances have these provisions, and if they don't, they should, that if it's a field change, a minor change, that's not something that they should have to go back to the planning board and get approval for. There should be some provision that the code officer can issue those kind of minor changes. But what I would say is that there should be a provision in your ordinance that says, hey, after the project, if there have been any field changes, we want an as-built, right? So that 20 years later, what's happened is actually documented. Now, you know, there should also be provisions for amendments, because I don't know about you folks, but we have situations all the time where they just don't come in for amendments. And again, 20 years later, what's on the face of the earth absolutely bears no resemblance to what actually was approved in 1987, right? We talked about right, title, and interest, standing, we talked about pending proceedings. Oh my goodness, FOA, the subject we all love to hate and hate to love. This is one of those situations where, again, as planner, you probably do play a helpful role. I mean, you're the front line as far as the notification of meetings, posting the meetings. The big one is this intersection between public proceedings and public records, right? It seems like, and this is where I think you guys have a really big, important role, is that we know what a public record is, right? Email, agendas, packet to the board, anything that touches upon the transaction of public business, right? That's a public record. And public proceedings are the meetings, right? But now, especially in this day and age, there is email and text and social media. And so if you have members of the board, say it's a 5-person board or 7-person board, if you have 3 or more folks starting to talk about the substance of what is before you with an application, that actually should be a public proceeding. And because there's a conversation between members of the board about a substantive issue that should be happening in public, that is a violation of FOA. It subjects people to, or the town, not individuals, but the town to, unlawful, basically violations of FOA, and a lawsuit can be brought. I will tell you, particularly in these days of partisanship, I am seeing so much more public records requests for emails, for texts, that kind of thing, because, you know, there's, I wouldn't go as far to say conspiracy theories, but people are very much more suspect of government. And I will tell you, and I'm sure you've probably seen these things, and this is why I'm saying to you, you've probably seen the emails going back and forth, where they shouldn't be, first of all, even if they're completely innocuous, but oftentimes they say things that you're just like, oh my God, did you really just do that? And so as part of your role, I think you can gently say, hey, let's save these comments for the meeting, right? And you may even want to say to the chair, again, I know it's not easy to do, but you might want to encourage them to print those emails out, make them available so that folks can comment on anything that's substantive. That's how you cure a FOA violation. In most cases, what's done can be undone as long as there's disclosure and, allowing the parties to make submissions on that. Waivers. Big difference between a waiver of a submission requirement and a substantive requirement. And now we're back to those bulk and dimensional requirements. I will tell you, ordinances, planning boards shall not allow waivers from minimum lot size, frontage, setbacks, okay? Because that is the purview, that's a variance, and you cannot have a planning board essentially grant what is a de facto variance. That's the job of the Zoning Board of Appeals. And so there's some kind of gray area where when I first read some of the cases, it was a buffer. You have to have a 20-foot buffer. I'm like, oh, that's a dimensional requirement. It isn't. Those things can be waived, all right? But when it comes to those hardcore space and bulk requirements, do not waive those. They can't be waived, all right? What else?
There was a question in the chat,
Good.
Leah.
I'm
about,
so happy. Please,
yeah,
let me hear.
about going back to sort of closing out the process. And the question is, should approved site plans and as-built be recorded at the county registry of deeds?
Oh, great question. So, yes, they should. Must they legally? No, not unless your ordinance requires it. So put that in your ordinance, okay? Unlike subdivision, which statutorily is required to be recorded, they Site plan is not required, but put that in your ordinance, make it a requirement. Consider even saying, hey, and if you don't record it within a year or 6 months, guess what? It lapses, right? So yes, definitely record those. I think that's a really important thing to do. Transferability of approvals. This especially applies when the project hasn't been completed and one developer is conveying to another. Approvals run with the land. That's the generally applicable principle. However, they can, in an ordinance, actually say, for example, I mean, if it's a big project and you know you were dealing at the outset with a reputable developer who had the money to complete it, and now you have some other person who you have no idea if they can, it does make sense to have in the ordinances that provision that says, you know, when it comes to technical and financial capacity, you need to show us that you can do so. You don't have to go through the entire review process all over again, but you might want to think about that. And I say that only just because I've seen those situations actually be problematic. And there is a case, this Town of Wells case, and I actually represent the Town of Wells, so that's one of the things I remember. Second request for approval of the same project, planning board says, nope, sorry, they don't appeal it. Can they come back and say, hey, how about now? Right? We really want to do it. How about now? A lot of ordinances say you can't come back to us within a year with the same project, but except unless I forget what the wording is, but a substantial change of condition, right? So if it's there, and for site plan review, say they had, you know, they're going to substantially change the application. If they change the color of the door, that's not a substantial change. It has to pass that straight-faced test, because of course, everybody's working hard. You don't need to be having a redo unless there really is some reason to entertain a second look. We already talked about vague. I won't go into that again. And I know we've jumped around a lot, but I really appreciate the questions. And if you have any more, I'd love to hear from you. Or not even questions, just again, especially from those folks who've been in the trenches for a while, if they have anything helpful to share, it'd be great. Erin, you look like there might be something in the chat. Is there possibly?
I'm checking, but I will say that the Joan from the Municipal Planning Assistance Program popped a lot of links to the cases that you were referencing.
Yeah, and that's
into the
a
chat.
good read. It's a really good read, and I'll be clear on that one. That was about, it was a shoreland permit. They had to get a driveway to their home, and the issue there was whether or not they could remove trees within that within that access way. And it was, you know, it was very interesting because both the majority decision and there was a very strong dissent, which I completely agreed with, but both were basically founded on the notion, look, these are volunteers. Nobody has, they're not real estate attorneys. Nobody should be getting into the weeds and doing an analysis of what the scope of an easement is. And so some attorneys say, oh, don't worry about that. It's really only limited to easement cases. Some are saying, no, this turns things on its head. Justice Connor, who wrote the dissent, basically said you're turning it on its head. So I think we have to kind of wait a little bit to see where that's going to shake out. Oh, I do see a hand. James.
Yes.
Sure, I'd say my town, Deer Isle, is probably a case study of mistakes trying to use a subdivision ordinance to handle a site plan application.
Mm-hmm.
So now we have a site plan review ordinance. But any kind, and I know if you're a lawyer, then you probably are looking at this as an opportunity. But for us, it's a real problem when you get mired in these long litigations where you've got very well-heeled abutters willing to throw every bit of money they need to try to stop something. Any kind of general advice for how you extricate yourself from that? How we've tried to turn the litigation over to the applicant and
Yes,
the abutters
that
and
was
try
my
to keep
point.
the
Yes,
town-
exactly. Yeah, yeah. All right, so that's a great question. And different
Yeah.
towns will do things differently, just because of the local flavor. Also because, sometimes a select board or council will want to say, look, the planning board decision, we want to support the, we want to support our board and take and really throw our hat in the ring and do what is necessary. But I will say a lot of towns, especially ones with small budgets, and especially for projects that really aren't like a burning legal issue. Like, for example, sometimes if it's, shoreland zoning or Airbnb stuff, which is a de rigueur kind of issue. If it's just hey, I want to build a porch on my house, the thought of the municipality is like, look, this is really between the abutters. And I think that I have seen in many cases where the town has said, look, they're the real true party in interest here, meaning the person who has an application, or I should say a permit. It's their job to take the laboring oar and to defend that application, that permit, that approval, and they just kind of step aside. And they, of course, the problem is because you're a named party, you're the defendant, the town of fill in the blanks is the defendant in these 80B actions, right? And so, but I have seen situations where the town has declined to submit their own brief. Often what I've seen happen is that the town works collaboratively with the attorney for the party who, got the approval that's being appealed, And what I have done in the past as a town has filed what I call a Me Too brief, where they will simply file one page that says, we have reviewed the brief of, such and such, and we agree, we are in substantial agreement with all arguments made. And literally leave it at that. Now, a hybrid approach is sometimes, and in fact, I'm doing this right now. I have a law court brief where same scenario, and we are in essential agreement. And also the attorney who's representing the permit holder is fantastic. Like, they're a really great attorney. So as the town attorney, I don't feel worried that somebody's going to do a bad job, right? I know their reputation. I've worked with them for years. And then but there was one issue that I'm like, yeah, I don't think so. So I would file that kind of hybrid brief where I would say, yes, we're in substantial agreement. There is one issue, however, we're not. And then I would brief that particular issue. So that's one way of handling it. Another way is to make sure, though, like I said, you don't want to see it again. So if there are those contentious issues, make sure those findings are really good. And it also, again, I'm not trying to say, hey, call your lawyer every time there's an application. No. But if you see a couple briefcases at that planning board meeting, you definitely might want to say, it would be good to have counsel at the planning board and advising the board to keep them on track, and also to draft those findings so that you don't have to. There's that. One thing you did say, James, that I triggered, that I had said as a blanket statement, oh, if it's a site plan approval, you don't have to record it. But there's always an if, and there's always a caveat. The caveat is the scenario you suggested is that if it's with respect to a multifamily dwelling that's being, that, as I said, that the subdivision law was changed. And if it's a situation where you're doing that, you have to meet all subdivision criteria, including recording that approval. Okay. So if it's that scenario, you don't have to record it.
I know, but it's even messier than that. It's like, and I don't want too far in the weeds, but it's a campground, but they're also putting these park model trailers on it, which aren't quite dwelling units, but they're awfully darn close, and they're for short-term, like weekly rentals. It's just.
Oh, I know. I feel your pain. I really do.
Yeah. We clearly didn't have our laws in place when that proposal came, and that moved us forward to actually writing the ordinances we needed.
As is often the case, that's what triggers the ordinance amendments and moratoria and retroactive moratoria. So yes, absolutely.
Thank you.
My pleasure. Thank you.
I'm not seeing anything else in the chat in terms of questions right now. A lot of very thank yous. Very helpful information. So I guess if I'll see if there's any other hands.
And
Otherwise,
while you're doing that, I want to say thank you, because truly, I'm a town attorney. I'm at meetings a lot, but again, reading the law and the cases and the statutes and the ordinances, that only goes so far, right? I love hearing your stories and your quandaries, because applying the legal stuff to the actual practical issues is really, really, all right. I'll say it's fun. I'll show you. I'm a total nerd. What can I say? But I really, you don't have to, you have to like your job if you're out 3-4 nights a week, right? And I do. So thank you for making it more fun. I appreciate that.